Everyone, welcome from Law with Dunk, the Law Guy, and today is day 33 of the Case a Day series journey, covering cases across criminal law, tort law, contract law, and the English legal system. Today's day 33 recording will have both a part A and a part B. If you ever have a case you want me to cover, feel free to pop it in the comments section and I'll get round to it if I can. In the day 32 recording, I touched upon Hyam v DPP 1975 and the early test used at trial for foresight consequences, being that of the highly probable test, which a jury could use to find an indirect intent for murder in this case. Now with part A. Before I progress on to today's case of R v Moloney, 1985, and how it helps illustrate the use of another old test for foresight of consequences, that being the natural consequences test, I should say that I really only advise my students to only really explain and apply the current virtual certainty test as of Nedrick and as of Woolen for foresight of consequences and thus indirect intent for crimes of specific intent, i.e. murder, and section 18 of the Offences Against the Person Act 1861. Also, when I cover attempts cases under Section 1 of the Criminal Attempts Act 1981, in maybe half a year's time, you'll be able to see that as of R v Walker and Hales, 1990, the mens rea of attempted murder can be committed via an indirect intent to kill. However, for any A-level law student, my advice when explaining and applying basic intent crimes would be to choose between a possible direct intent, as of R v Mohan, or subjective recklessness, as of R v Cunningham, when trying to prove mens rea. In my opinion, it's just easier this way, and recklessness gives students a better alternative to direct intent, in my opinion, rather than having to explore indirect intent, which is phrased in quite a rigid way, as it involves the words death and serious injury, which aren't present within most of the non-fatal offences against the person. And that's the end of part A.